Here's what we're going to do. I want every strategy we've got on near-Earth object collision, okay? Any ideas, any programs, anything you've sketched on a pizza box or a cocktail napkin. For 30 years, I questioned the need for NASA. Today, we're going to give them the answer.
Back in 1974, we first got the idea, the possibility that a meteor or an asteroid...
I need somebody who's had a little less caffeine this morning, Doc.
Come on, guys. We got to come up with something realistic here. We got 18 days. That's 431 hours, 15 minutes, and 18 seconds. Time's a luxury we don't have. What?
Like you, be strong to hold the powers of the sun. To dream, believe.
Let's listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I am your host, Pavarotti, and I'm here to discuss the Idaho 4 case. And I've got a very, very informative one for you today, folks. We got new court docs that I discussed in the case summary yesterday. And as I began to go through the court docs, I came to a realization. The law is a very complicated subject. So before I went and put this video together, I spent a lot of time researching so that I bring you the most accurate information that I can. And I realize now why it takes so many years of law school to be able to be an attorney. And just understanding the laws and how they apply in different states and the proper procedures for things is not an easy thing to grasp. That's why I get kind of perplexed when I watch the attorneys, go through some of the things in this case, and they go through it fast, and they don't really explain things like what's supposed to be taking place when, how things work. And I realize now it's hard for them to explain because it's different in every state. So I've spent an inordinate amount of time studying the procedures and just how everything is supposed to work in a case like this in Idaho. And I've learned some new things, and I'm going to be sharing those things with you in this video so that we clearly understand what's going on, what's the strategies, and what is the likely outcomes. And what's interesting is as I was doing that, something became very clear to me, and I will share that with you at the end of this video because it just makes all the sense in the world. I believe I figured out what the defense is going to be doing, and it relates to those, transcripts that we got the other day from that January 23rd hearing. Some of the things that were brought up and discussed in that hearing, were perplexing. Now I think I understand why they were brought up and discussed and why specifically the defense called the two experts that they called. Hang out for the end for that one. But I'm going to break these things down. We've got several docs. Instead of breaking up a bunch of videos, I'm going to go through them all in this video and make sure that everybody clearly understands what's going on. So with all that being said, we're going to dive into the first one, which is one of the motions in limine filed by the prosecution. And this is not one to exclude evidence, it turns out. When I read the case summary, I assumed they were trying to exclude demonstrative things that the defense was going to try to be doing. But it turns out they're simply trying to include a demonstrative model of the King Road residence to be shown at trial. And we'll take a look at that model that they want to be shown, and we'll take a look at those docs related to it. And then we'll move on to the more pressing ones. Okay, so this is the state's motion in limine for the admissibility of demonstrative exhibits and the memorandum in support of that. So the state moves the court for a pretrial order regarding the admissibility of demonstrative exhibits. Specifically, the state will seek to introduce a three-dimensional model of the 1122 King Road residence for demonstrative purposes to aid the witnesses in their testimony. Yeah, I bet it's going to aid the witnesses in their testimony. You mean the witnesses like your crime scene analysis person, the only one you're going to use? So the argument for this is, in this case, the state anticipates introducing a three-dimensional model of the 1122 King Road residence, and this model will consist of 3 levels, which can be removed by level to show the interior layout of the residence. Yeah, that little bitty model is really going to show a jury the interior layout of the residence and give them a good idea of what they're looking at. I doubt it. The interior layout will depict wall and door placements, but no furniture or human depictions. No furniture, huh? Well, I think having furniture in there would probably be, more accurate, considering, you have to maneuver around furniture when you're doing something like this. But I'm sure y'all made this thing where it was, as prosecution friendly as you possibly could. And it'll be placed on a rolling table for portability within the courtroom, which means it can be placed out of the way when not in use, I bet. Who's making it? The model's being constructed by the Federal Bureau of Investigation. So, why does the FBI have to make that model? Y'all can't make it yourself? Oh, yeah, because the FBI is the one that has the real skin in the game in this case, isn't it? So, They do all this, and then they give a picture of what this model is supposed to look like, and you'll see it right here. And it's 3 foot wide by 4 foot wide, or at least the table's 3 foot wide by 4 foot wide, stands 52 inches tall. So the actual model, though, looking at this, this dimension they've put together, it looks like that actual model is probably closer to 30 inches, so 2.5 feet by 3 feet probably. So, it's a pretty decent sized model of the house, but it certainly isn't going to depict, it's not going to give the jury, the mind frame that they need to have to really understand this house, its layout, how thin the walls were in this house, the fact that Dylan's room is directly underneath the room where 2 of them were unalived, and the only thing separating them was a couple of 2x6s vertically with a piece of sheetrock on her ceiling, a piece of 3/4 inch plywood on their floor, and some carpet and pad. She would have heard every single thing that went on up there. And that's certainly not going to depict that, but that's their model. So here's a better representation of that model. You can see it in, sitting up. This is how it's going to look on that table. And this is what they're going to be showing to the jury in place of the actual house that they tore down. So you can bet they did this because this is going to be more beneficial to them than them actually seeing the real King Road residence. So there's that one. The next one we're going to look at is the motion in limine from the prosecution to exclude the defense's alibi. Now this one is kind of important, I believe. It's important in different ways, and I'm thinking that the ruling on this can go either way, because although the defense should have absolutely given the alibi a complete statement by now if they were planning on using it, and they are, but it really does have a big impact on the case. And I don't know how the judge is going to rule on this one. I would think the judge would rule in the defense's favor simply because of the lack of specificity by the prior judge, because he seems to roll off of John Judge's rulings on a lot of things. But the fact that John Judge never ruled on this makes it interesting. But first, let's talk about what entails this alibi before we get into their motion in limine to exclude it. Okay, the alibi defense. Although through cross-examination of experts, it can be implied that he was at Wawawe The defense cannot expressly say that. He was there and not the King Road residence. And this is important because, I mean, that's in, arguments and open and closing statements. If they exclude the alibi defense altogether, unless they put Bryan Kohberger on the stand and he expressly says it, then that's going to eliminate the attorneys from being able to argue it. In Idaho, if an alibi defense is excluded, it significantly limits the defense by preventing them from presenting evidence that the defense was not at the crime scene at the time of the offense, essentially taking away a key strategy to create reasonable doubt in the minds of the jury, and potentially making it much harder to prove innocence. So this one is very important. Now, the bone of contention is with the alibi defense, you're supposed to, be able to name a witness that will corroborate your alibi. Well, if you don't have one, if you're out driving around by yourself, then you don't have that luxury. So it makes, the entire alibi defense kind of, it's kind of a catch-22 as far as it goes as it relates to Kohberger. But let's look at some other aspects of this. Okay, so no evidence of location. The defense cannot introduce witnesses or other evidence to establish where the defendant was at the time of the crime, which is the core element of an alibi defense. So if Cy Ray had some type of digital evidence that proved that Kohberger was at Wawa Park, he would not be able to actually show that evidence, because if it's excluded, that would be other evidence to establish where he was at the time of the crime. Now, I firmly believe that it was Cy Ray that was going to confirm that 7 minutes after Kohberger left his apartment, he was heading directly towards Wawa. Not that he actually had some type of digital evidence to prove he was at Wawa. Now, the limited ability to counter prosecution narrative. Without an alibi, the defense is largely restricted to challenging the prosecution's evidence directly, rather than presenting a competing narrative about the defendant's whereabouts. I think that's very important, because as you go through this case and through this hearing, this trial, it's going to be very important not only to show alternate suspects and how they could have done it, but it would also be important for the defense to be referring to the fact that Kohberger was at Wawa and not at the King Road residence during this time, and they won't be able to do that. Potential prejudice to the defendant. A jury may infer guilt if they are not presented with an alibi defense, even if the prosecution does not have overwhelming evidence, as it might appear the defendant has no explanation for their whereabouts. See, this is a big deal in this case. Important factors to consider. Notice requirement. Idaho law requires defendants to provide advance notice to the prosecution if they intend to use an alibi defense. Failure to do so can result in the exclusion of the alibi evidence. Now, we know through the court record that they did provide the prosecution with evidence and the fact they were going to be using an alibi defense, but they could not produce a full timeline of his whereabouts. And that's where the bone of contention is. And I don't know why they never finally submitted to the prosecution their whereabouts, or maybe they did in discovery and we don't know. And it's finally, you see, judge's discretion. The decision to exclude an alibi defense rests with the judge, who will evaluate the reasons for non-disclosure and the potential prejudice to the prosecution. So it comes down to the judge's discretion. Now, this is going to be key because, like I said, although this judge rules against the defense in every possible way, he does seem to piggyback off of John Judge's decisions, though, even if it's not one that he would have made. So when we look at this motion in limine to exclude the alibi, they included, and I'm going to go ahead and read most of this one to you because they included excerpts from prior hearings, and it shows us some of the information that I feel like is important as it relates to this issue. Okay, so this is the state's motion in limine to exclude the defense's alibi. And you can see down here it says, by way of background, the state refers the court to the following. And you can go back to a video that I did a while back where I went through every piece of documentation in the court record as it relates to the alibi, which are all these things the state is actually putting up here. And I showed you what was said and the fact that at the end of it, we never got a ruling from the judge. Or if we got a ruling, it was sealed and we never knew it. But he mentions that May 23rd, the request for disclosure of the alibi, July 22nd, the motion to compel the defense to produce an alibi or to bar the evidence, and then the defendant's objection to that, and then he's attached a partial transcript of the August 18th court hearing relating to the alibi. So remember, I told you about a week ago that one of the court docs was that the judge was releasing the audio versions of those hearings to the state. I thought they were releasing it to everybody. They weren't. Some of y'all pointed that out to me, that they were just releasing it to the state. And this is why they did that, because the state took those audio recordings and used it to create a transcript to give to the judge in this particular ruling, or this particular motion. So he's got excerpts from that court hearing on August 18th. And then on August 22nd, he's got the scheduling order from the judge. Then the state's December 21st motion for scheduling order, the order setting deadlines for hearings, which in paragraph sets an alibi compliance deadline of April 17th. But then April 17th was that's when the defense actually, this is what I told y'all in the past, where all HELL broke loose in this case. Because when the defense in this April 17th response to the alibi request, this is where the state kind of lost their mind. And that's when they replied with that sealed response that said the probable cause affidavit was irrelevant at this point and all that. And then the defense responded to that sealed document with an unsealed response that was very telling. And then all of a sudden they rescheduled hearings and everything, and then we never knew anything else about this. It just kind of went away, which was very weird. And I brought that up several times. But then and that's what he's referring to here on the state's response to notice of defendant supplemental response to the alibi on April 26th, that was sealed. And then former presiding John Judge's June 27th scheduling order, which is subsequent to the April 17th alibi disclosure deadline, which makes no further reference to alibi. Right, so this is where everything got weird. The judge was supposed to set a deadline and he didn't. So we'll just have to see what takes place with this. But as we go down here, I'm going to read you these attached transcripts of that hearing they had. Again, everything's Exhibit S1. When we go down here, this is the excerpts from the August 29th hearing, and it says starts with the court. So this is John Judge. Okay, so the next motion, I believe, is the state's motion to compel notice of defensive alibi. Mr. Thompson. Yes, sir, thank you. And Judge, since the filing of our motion, looking at the defense's response, it looks like we have made a little bit of progress. The defendant has at least, Mr. Kohberger has at least now stated that his alibi is he was out driving around that night. So he acknowledges right here that the defendant has stated that is his alibi. We knew that already, and if that's his alibi, so be it. All right, so if that's his alibi, so be it. All right, so why are you trying to exclude it, prosecutor? What the defendant has still failed to do is comply with Idaho Code 19519 and Idaho Code Court Rule 12.1 that specifically requires a defendant to identify the names of witnesses who will be called to support the alibi along with their addresses. Well, if he doesn't have one, he can't do that. The defendant has only said, well, I may do that, or I may call witnesses, or I'll do it through cross-examination, and of course, I have the right to testify on my own behalf. We don't question that. At this date, I do not believe it is possible, even if the defense were to provide a list of the names of witnesses and addresses today, that with everything else that needs to be done leading up to a week before October 2nd, So that's October 2nd was when they had the trial scheduled at that point, that there is any way that the state could reasonably expect to respond as contemplated by the rule and the statute. So the state's position at this point is we will accept what the defendant has to say, that he was driving around. So the state's position at this point is we will accept what the defendant has said, that he was driving around. Well, if you accept that, why are you trying to exclude it then, Thompson? Although he should specify where he was driving. If he's not going to call anybody else, if he's not going to offer evidence from anybody other than himself, then that's none of our business. So we are willing to accept that with an order from this court prohibiting the defense from offering third-party evidence, whether by direct cross-examination in support of defendant's claimed alibi. All right, so they don't want him to be able to offer third-party evidence like a Ray. If he wants to testify to that, that's his prerogative, but at this point it's too late for the defense to comply with the statute and identify specifically people and their addresses who would testify. So that's where we stand now, Judge. Thank you. And of course, John Judge, Mr. Wishy-Washy, says, all right, thank you. Who do I, Miss Taylor? Okay, it's me, Judge. All right. Your Honor, we have provided to the prosecutor what we can provide to the prosecutor and more. I think that Mr. Thompson is right. We don't have to tell the prosecutor if Bryan is going to testify or what Bryan might say. We have indicated that that it's possible that we would have additional things that might come out through expert testimony on cross-examination of the state's expert. So the reason she's saying it might come out through cross-examination of the state's expert is because at this point in time, Thompson, even though you're going back and pointing to this, you had not provided the defense with the cast data, and you know it. I don't have documentation to give the state today because the state hadn't given it to us. I'm not going to go into any more about it at this moment. I understand when October 2nd is. I definitely understand that, and I've heard everybody's thoughts and concerns. I get that, but I mean, this is what we have, and when there is more, I will provide it. Again, they couldn't give the entire alibi because they knew the FBI would adjust their cast to match it. So they couldn't give them specific testimony until they got that discovery. Okay, thank you. Any responses? John Judge, Wishy-Washy. Mr. Thompson, Your Honor, with all due respect, that is exactly what the rule and the statute are designed to prohibit. As the U.S. Supreme Court observed in Taylor v. Williams, the ease with which an alibi can be fabricated. The defense is waiting to gather up evidence, seeing what they can fabricate to match that evidence. Say, oh, by the way, here is our alibi now. You see, Thompson has no problem in saying the defense is waiting to see what they have so they can fabricate and match that evidence. I wish Ann Taylor at the time would have said, Your Honor, the state is waiting for us to give our evidence so they can fabricate more evidence to what we say. But I understand she was playing it cool, and Thompson just says whatever pops in his head. That is specifically what is prohibited by the statute, into recordings. All right, and then we get to the trials are not yet a poker game by which blah, blah, blah. The court. Now, this is where Mr. Wishy-Washy never did anything. The court, John Judge. Okay, thank you. Well, the way I understand this is, and this is the so-called alibi, not really an alibi, but, quote, he was out driving during the late night and early morning hours of November 12th to 13th, 2022. So what I'm going to do, because the next motion is for a scheduling order, I'm going to address this in terms of a deadline, and we'll see how that goes. So right here in his word salad, he finally says he's going to express it in terms of a deadline and see how that goes. But does he do that? Right now, that is as far as Mr. Kohberger wants to go with regard to alibi, and that's fine. All right, so he says that's fine. That's as far as he wants to go right now. But if there is going to be, and Ms. Taylor, you suggested that there might be some witnesses, then you need to cough them up by a certain date, certainly before trial. What certain date, John Judge? I've read the Albert case, which is interesting because there were late witnesses. The judge refused to allow them to testify, and that case was overturned by the Supreme Court. or not the Idaho Supreme Court. Maybe it was a court of appeals. I don't know. This John Judge was not real bright. I'm not looking at it. But then Perez, that was 2021. That was a court of appeals. And they said, out of luck if you're too late. And so I think Miss Taylor, so basically the judge in his mind is going through, that was the Supreme Court. Now the state, maybe it was state Supreme Court. Maybe it was an appeals court. And then another one said you're too late, and that was an appeals court. So in his mind, he's going, I don't know what the freaking law is. But Miss Taylor, you acknowledge that potential risk to your client in your latest response to the request. So this statement right here, I think, may hurt them. You acknowledge that potential risk to your client in your latest response to the request. So there is, there's some potential balancing there. Word salad. And certainly Mr. Kohberger doesn't have to say a word, and that is protected by the Constitution of the United States and Idaho. All right. So I think that takes care of that for now until I'm going to give you the deadlines. So I think the last motion then, and again, this motion to dismiss, but he never gave the deadlines. That was the last anybody ever heard of it. So when this John Judge says, all right, so I think that takes care of that for now until I'm going to give you the deadlines, he never did anything. So the fact that he did not ever give a deadline, I think, lends to the defense. So if the judge looks at this and realizes how ridiculous John Judge's rulings were, or failed to rule was, then I think he's got no choice but to rule in the defense's favor at this. But we've seen how he rules so far. But that is, that's the end of the alibi, and it's important for them not to exclude that one. I think we're 50-50 on whether that gets excluded or not. They can still bring up through cross-examination that Kohberger was headed towards Wawawe, but unless they put Kohberger on the stand and he says, I was at Wawawe, the defense will not be able to use that in their actual arguments, which will make winning the case much more difficult. So there's that. So I know the alibi one is about as clear as mud, and it's hard to get a handle on it because, I think at some point the defense should have presented to the prosecution the rest of the alibi statement, but they never did. Now, I have to assume that they didn't for a reason that's part of their strategy. On the flip note, it's clear as mud because John Judge never ruled on it, and then nobody ever brought it up again. And I've said this in many videos. This was something that's been frustrating me for over a year now. So I don't know. There's no way for me to determine what, the probable outcome is because there's too much mud in the waters on this issue. So we'll just patiently, keep our eyes on this one. Now, the next issue, though, thanks to one of my wonderful people in my comments, they brought this up to me as I was going through the video yesterday as it relates to the neuropsychological and psychiatric expert testimony. And it makes it clear as day what this is regarding. So thank you for that. I don't remember exactly who it was that put that in my comments, but good job. Let's take a look at the motion to exclude, the motion in limine to exclude the neuropsychological and psychiatric testimony or evidence, and then I'll show you what 99.9% is more likely the scenario relating to that. Okay, so what we have here is the state's motion in limine to exclude neuropsychological and psychiatric evidence. And what they specifically say is the state objects to the proposed testimony of expert witnesses identified in Exhibits D7 and D13 appended to defendant's supplemental response to request for discovery regarding expert witnesses. So that means in the expert witness discovery that the defense gave to the prosecution, they have listed these experts in neuropsychological and psychiatric evidence that they are going to be presenting. They're wanting to get that excluded, and it looks to me like they're freaking out. And it says it provides that mental condition. It talks about the Idaho rule that mental condition shall not be a defense to any charge of criminal conduct except expert evidence on issues of any state of mind which an element of the defense. So what they're saying is they're scared that they're going to use neuropsychological and psychiatric expert testimony to say that Kohberger's crazy. That's what the prosecution is afraid of. And it says in each of the witness summaries, the defendant specifically states the testimony is not intended to be a mental element defense pursuant to the code, but rather this testimony is about state of mind as well as factual defense testimony to anticipated testimony elicited by the state. So as such, this proposed testimony falls outside of the mental condition evidence allowable under Idaho law. So they're saying that even the defense is saying this is not going to be, testimony about insanity defense, but the state is scared of it being that. And I'm going to explain why the state is doing this here in just a minute, because it turns out, as I studied the Idaho rules of procedure, the defense actually doesn't have to tell the prosecution in discovery exactly what their plans are for things like this and the alternate suspect defense. So the prosecution sees little things in the defense's discovery and they anticipate, this is maybe what they're trying to do. So they file a motion in limine to exclude the evidence as a fishing expedition. This is a fishing expedition. They want a hearing so that they can get the defense to tell them what their strategy is in court in hopes that they can get the judge to exclude it in that motion in limine hearing. So this is them guessing what it is and then filing a motion in limine to be able to fish and figure out exactly what the defense is trying to do. Well, I don't believe that's even necessary as it relates to this, because I'm going to show you what the defense was trying to do with this, and it has nothing to do with an insanity defense. You see, when assessing someone for obsessive compulsive disorder, OCD, a neuropsychological test focuses on evaluating cognitive functions like memory, attention, and executive functioning through standardized tasks, while a psychiatric test primarily involves a clinical interview to assess symptoms and behaviors related to OCD, utilizing diagnostic criteria to confirm the diagnosis. Both are often used together to gain a comprehensive understanding of the individual's condition and guide treatment plans. Also, neuropsychological testing and psychometric testing, when used in the context of ADHD, are specialized assessments that evaluate various cognitive functions like attention, memory, executive functioning, and processing speed through standardized tests, helping clinicians identify patterns potentially indicative of ADHD and understand the underlying cognitive strengths and weaknesses of an individual, thereby informing treatment plans and interventions. So when we go back over to their motion in limine, and we see right here that the defense is saying that this testimony is about state of mind as well as factual defense testimony to anticipated testimony elicited by the state. Well, how would that apply to this? Well, what is the state going to testify to? They're going to testify to the fact that when they had Bryan Kohberger on video at the grocery store down there at Albertsons, that he actually had on surgical gloves as he was in the store. And then they're going to be testifying to when they did the raid on his house in Pennsylvania, that he was wearing rubber kitchen gloves and putting trash into sandwich baggies. Well, they're going to say that he was doing that because he was trying to cover his tracks, while the defense is going to be showing or providing neuropsychological and psychiatric experts to testify that Kohberger is OCD and he likely has ADHD. And that is why he is wearing gloves when he does stuff like that, because that is a symptoms a symptom of a obsessive compulsive disorder, not of a psychiatric illness that would cause him to go and unalive 4 people. So thank you so much for that comment, and I believe you're exactly right. Now we're going to get into the big one, which is the motion to exclude alternate suspect testimony and evidence. And as I read this filing in their motion in limine yesterday, a lot of questions came up in my mind, because it was my assumption that through defense discovery, they had to discover to the prosecution what their plan was as it related to, say, the alibi, the expert witnesses that would be testing as far as neuropsychological and psychiatric testimony, as well as provide them with the discovery that they were going to be using for alternate suspect defense. And as I read their filing yesterday, it made me take a step back and go, well, wait a minute. Something isn't adding up here. So I began researching. First question I had was, does the defense in Idaho have to provide to the prosecution discovery on their alternate suspects? Turns out, no, they don't. So my next question was, well, then how would the prosecution even know to file a motion in limine to exclude the alternate suspect theory and evidence? And then my next question was, if they didn't know what it was to exclude, how can they file something to exclude something they don't even know exists? So I did a lot of research, and let me share some of my findings that I think will shine a light on what's going on in this case. All right, so you can see in Idaho, while the defense is not explicitly required to disclose an alternate suspect defense to the prosecution before trial, under Idaho Criminal Rule 16, Discovery and Inspection, they are generally obligated to disclose information that could negate the defendant's guilt, which could include evidence pointing towards another suspect. If requested by the prosecution through a written discovery request, however, the specifics of when and how to disclose such information may be subject to court interpretation and case law depending on the circumstances. So there really is no set way to do this. The defense doesn't have to disclose alternate suspect defense to the prosecution. Now you can see it says reviewing discovery documents. The prosecution will carefully review all the documents provided by the defense during discovery, which could include witness statements, potential alibi information, or any evidence pointing to another possible perpetrator. So when the defense turns over their discovery of witness statements and other information, I'm assuming a lot of it's probably going to have to do with the blood. Well, it kind of lets the prosecution know that the defense is going to be pointing to evidence to another possible perpetrator. And then it says in pretrial hearings, in some cases, the defense might need to present arguments about the admissibility of evidence related to an alternate suspect during pretrial hearings, allowing the prosecution to understand their strategy. What this right here means, in some cases, they might need to present arguments about the admissibility of evidence related to an alternate suspect during pretrial hearings, allowing the prosecution to understand their strategy. That means if the prosecution gets wind based on the defense's discovery that they're going to be trying to present evidence pointing to another perpetrator, then the process is the prosecution will file a motion in limine to exclude possible alternate suspect defense. And the reason they do this is, again, it is a fishing expedition. By them filing that motion, when they go to the hearing, the defense will have to divulge to the prosecution what they're planning on doing so that the judge can rule whether or not it's admissible or not. So the prosecution has got in their mind the defense is going to be using alternate suspect defense. They filed the motion in limine to exclude it. so that they can learn what the defense's strategy is in the hearing for the motion in limine. So whether the judge excludes it or not, it'll gain insight by the prosecution into the defense's strategy at trial. So it's a game of smoke and mirrors and 3D chess, folks. That's all these things are. In Idaho, where the defense is not required to disclose an alternate suspect defense, the prosecution can attempt to get it by excluding, the prosecution can attempt to get it excluded by filing a motion in limine to request a pretrial hearing where the judge can argue that alternate suspect evidence is irrelevant, unfairly prejudicial, or confusing to the jury, potentially relying on facts like the strength of the alternate suspect's connection to the crime and the potential for misleading the jury. The burden would be on the prosecution to demonstrate the problematic nature of the defense strategy without knowing the specifics of the alternate suspect beforehand. So that means they don't have any of the specifics before they file the motion in limine. So it's going to be on them during the hearing to come up on the fly with a strategy to get it excluded because they don't know what the heck they're trying to exclude right now. It's a fishing expedition. And that's what this motion in limine is designed to do, uncover the defense's strategy and then try to get it excluded on the fly during that hearing. So everybody is on the same page why these motions in limine are being filed. The prosecution doesn't know what the defense's strategy is. They file these motions in limine to exclude the possible evidence so that they can uncover what the defense is trying to do in the hearing. So when you follow this limine timeline as it relates to alternate suspect, we start with the prosecution. Prosecution suspects the defense is going to use alternate suspect evidence in the trial. Then the prosecution files a motion in limine to exclude the evidence. This is done as a fishing expedition to uncover the defense strategy as it relates to their evidence and plan for the alternate suspect to be brought up at trial. Then we have a limine hearing. This causes a hearing for oral arguments to bring out the defense's plan and give the prosecution a chance to argue against its admissibility. And then finally, it ends with the judge's ruling. This gives the judge the authority to rule on how much, if any, of the argument can be brought up at trial. So I wanted to go through that because those were the questions I had in mind as it relates to procedure on these matters, and I wanted y'all to clearly understand the proper procedure in Idaho and what all this is doing that we're watching transpire right in front of our eyes. Now let's take a look at the prosecution's motion in limine to exclude to exclude alternate suspect defense. Okay, so we've got the state's motion in limine regarding the alternate perpetrator evidence. And it says the state moves the court in limine for an order prohibiting the defendant from offering alternative perpetrator evidence or argument without first satisfying the court that any such evidence is relevant and admissible pursuant to Idaho rules. So again, it's a fishing expedition by the state in hopes to exclude any of the evidence. The state doesn't know what alternative perpetrator evidence that the defense is going to be presenting, so they're having this hearing to satisfy the court that this evidence is proper and should be admitted at trial. So, fishing expedition to try to uncover the defense's strategy. And it says that the Supreme Court noted the trial court must first consider and determine whether the proffered evidence is relevant under the rule. The second step is determine whether the probative value of the proffered evidence is substantially outweighed by the danger of unfair prejudice. I don't understand this. If you've got evidence of an alternate suspect and it substantially outweighs the danger of unfair prejudice, confusion of the issue, misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. Well, substantially outweigh the danger of unfair prejudice. If you've got more evidence to an alternate suspect than they have against your defendant, then I don't think that should be an issue. noting the Larson court was concerned that a defendant will attempt to admit evidence where the sole purpose is to infer an individual other than the accused that committed the crime. So, yeah, I mean, that's exactly what you want to do. But anyway, in this case, during the course of the investigation, literally thousands of tips regarding possible perpetrators were received by law enforcement. With the exception of information regarding the defendant, none of these tips were substantiated. Well, were they not substantiated because they weren't good tips or because y'all were focused on the defendant and not the other tips? The state submits that any attempt by the defendant to offer or argue an alternative perpetrator theory without evidence specifically connecting persons other than the defendant to the homicides would do nothing more than mislead and confuse the jury and would also result in undue delay, waste of time, would be a needless presentation of cumulative evidence, and unfairly prejudice the state. Who cares? Under the Idaho Supreme Court's ruling in Meister, this should be prohibited. So what the state is arguing, because they don't know what they're arguing against right now. Again, it's a fishing expedition. But the state is explicitly stating if they don't have evidence specifically connecting the persons other than the defendant to the homicides, then that shouldn't be allowed, whatever the defense has. Well, I state that they've got video of perpetrators walking towards the King Road residence, cocking their gun right at the time, right before the atrocity, and leaving directly after it when the law enforcement says it happens. You got a guy walking, looks like a knife out of a dumpster, walking to the house before, and then getting picked up saying that's it afterwards. I think that's direct evidence to the crime. And then you've got the number one suspect, Farley, somebody yelling, "I see you, Farley," right before the atrocity at the apartments next door to the house. Those are all direct evidence. But then it became clear to me something that I had not previously thought of, and it's the blood. And what really made me think of this was listening to a super guilter go over a certain aspect of the case in his terrible interpretation of the transcripts the other night. And when he said this, I went, oh my God. Let me share with you what I think has actually happened here, folks.
Of course, everybody knows you have to preserve it. Of course you do. But once you test it, it doesn't mean there is always going to be enough. Okay? And that's why if you've got gloves and you're the defense and you want to test something, then test it. And if they use up the sample in that glove in the defense labs, then guess what? Everybody is on the same page. Okay? They're on the same page. And that's why if you've got gloves and you're the defense and you want to test something, then test it. Then test it.
I don't know why, but when I heard him say that, my mind went to those transcripts from that closed hearing. And then I began to think. And you sometimes just really have to think on a whole nother level as it relates to this case. Because many times you've heard me say that I believe that the defense is playing 3D chess. So everything they do, they have a reason to do it. And it may not necessarily be the reason that we're looking and watching and seeing. So when I refresh my memory on the transcripts of the closed hearing, especially as it relates to all of the testimony around the DNA experts, you see in that closed hearing, the only people that testified was Brett Payne, and that wasn't really testifying to the IgG stuff, Rylene Nolan, Matthew Gamet, Mr. Hellwig, and Miss Larkin. And then I remember their testimony and the questions that was asked by Ann Taylor. Most of the questions determined the process for developing a SNP profile and the process for searching it via IgG genealogical searches. But occasionally she would mix in questions about unknown male B, blood on the handrail. I don't believe she ever mixed in a question about unknown male D, blood in the glove, but she did mention unknown male B, blood on the handrail, several times, and she really didn't get an answer for it, and she didn't press for more information about it. Now, when I look back, though, and I think about the testimony of Mr. Hellwig, and he is a defense expert, and what is his expertise in? He runs an accredited lab, unlike Othram, that takes DNA samples and creates a SNP profile. And then I think about the testimony of Leah Larkin. Her actual expertise is taking that SNP profile that Mr. Hellwig would make and performing the actual genetic genealogy search to locate an individual. And then it hit me like a ton of bricks. If during that testimony, Ann Taylor was getting on the record the process by her experts and the prosecution's experts as it relates to the procedure for IgG, and she is presenting both of her experts to give their opinion on the process, but at the same time mixing in just a question here and there about unknown male B, does that mean, after listening to Mr. McDonough's statement, that the defense has every right to take and do their own investigating on that sample? That leads me to believe that the defense could have acquired unknown male B, give it to Mr. Hellwig to create a SNP profile, which would then be given to Ms. Larkin to do a genetic genealogy search, and they may have identified who unknown male B on the handrail actually is. And that, my friends, would be direct evidence for an alternative suspect theory. Just to be sure, I did a little research, and in Idaho, the defense can access crime scene DNA samples and conduct their own analysis on them. But they must follow legal procedures and typically need a court order to do so. In recent cases like the University of Idaho killings have seen judges generally allowing access to DNA evidence for independent analysis, while ruling that the defendant has no reasonable expectation of privacy and DNA left at a crime scene. Well, then we think about, the DNA on the handrail and in the gloves, and then you start thinking about Mr. Hellwig here and Ms. Larkin, and I think the pieces of the puzzle are starting to fit. That was a lot of information, but please let me know your thoughts. Oh, also, please like and subscribe to the channel, post your comments, thoughts, your criticisms, and until next time, Pavarotti's out.
To dream